So what would you like?
I'm asking, I have the scram on and I have the monitor on, and for the curfew, I'm asking, my son has to be to school at 6 o'clock and my curfew is 7. He plays basketball, he's in sports, so they have
I got it.
practice before school.
You
And he
want
goes to
5:30?
school out of district, so I'm asking if I can have 5:30.
Okay.
I take him to school and I come right back home, and I don't have a problem with my curfew. And then I wanted to also ask, with the scram and with the monitor on, if you can reinstate my driving privileges, because twice my son has been late
Oh,
to school.
Well, I was gonna pull her record,
I don't know what your driving record is. I mean,
yeah, I didn't know about her privileges. I know she has an interlock device, but I didn't know that
I
her
don't have an
privileges.
interlock
run-
device. I don't have an interlock device.
All right,
Oh, you don't?
No, because I don't have a car. So, but my sister let me use her
Why are
car
you saying
No.
you don't have driving privileges?
because when I came to court, I thought
He told you not to drive. Okay, I
Yeah, he
gotta
told
look
me
at your bond
not, yeah, he told me
conditions.
not to
Okay.
drive into court. And so,
As
I
a note,
came
Your Honor,
to
it's
court
eligible
to-
with the last suspension ending in April of
read
2024.
me the Dennis, please.
Yes, Your Honor. So on January 18th, 2024, the officer observed a vehicle failing to drive in a single lane at the 8600 block of West Grant Parkway. The defendant was swerving in and out of 2 lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The officer observed disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide an ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Center field sobriety tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.29 and 0.294.
Does she have any other open DWIs or anything?
This is the one where she has an open DWI out of Austin County.
That's why. You have 2 open DWIs. I don't want you driving. You're not allowed to drive. If I find that you drive, I'm gonna have a contempt hearing. So I hope above all else, you are not driving. You heed this warning, Ms. Keys. You are not allowed to drive. If I find that you're driving someone else's car in violation, you're looking at 6 months in jail every single time you have signed an affidavit promising you that you're not going to drive. I don't care what is going on in your life. You have 2 open DWIs. There's alcohol in the car allegedly. Unacceptable.
And then opening up my privileges, the reason why I asked is because also, unless I sign over custody of my kid, I'm the only one that can sign him to school. So what's been going on is I have to ride with her to drop him off and then she brings me back.
Okay.
I have not
I will-
violated any
If you
conditions
want
of
me
my
to
bond.
open up the curfew, I
Okay.
will, but
Okay.
I don't want you driving. Do you understand?
Yes.
There is a method to our madness here. And 2 open DWIs, a 0.2 with alcohol in the car tells me that there is an issue. The last thing I want is someone dead. Do you understand?
Yes, Your Honor.
Okay, I will open it up to 5:30. I hope, because imagine what's going to happen to your child if you go to jail and I make your bond $50,000 and you don't have anyone to make it. You understand?
Yes, sir.
Okay.
All right, just
Yes,
thank you.
ma'am.
May we be excused?
Yes, please.
Does she need to sign them?
She will need to sign yes, the condition, yes. Matt, do you mind giving it to her? Thanks.
Page 13.
Good morning, Ms. McCardle. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 25th, 2025, the officer stopped a vehicle for failing to maintain a single lane of traffic at the 3300 block of NASA Parkway. The officer observed the vehicle failed to maintain a single marked lane multiple times, and the vehicle had no license plate. The officer initiated a traffic stop, and the officer made contact with the defendant, the driver of the vehicle. The officer observed a strong odor of an alcoholic beverage, slow, delayed speech, and the defendant was asked to exit the vehicle, and the officer performed center field sobriety tests. HGN 6 out of 6, And then the defendant was then transported back to the station to continue testing, where he refused any more testing. The DIC was read and the defendant refused a breath test. A blood search warrant was signed and executed.
Mr. McCardle, I'm going to find that there's probable cause to go forward with your case. Any prior DWIs?
No priors, Your Honor, and I'm running a license right now.
Please. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. No more PR bonds. You understand?
It's eligible, Your Honor.
As long as you have a valid Texas driver license and liability insurance, you may continue to drive. If you do not have either, then you're not allowed to drive. You've got a great lawyer. Listen to her. She'll take care of you. Because you have her representing you, I will waive your appearance so you don't have to waste your time coming to court. But you must stay in touch with her. If she tells you she can't get a hold of you, you pick up a new case. You've seen what happens, right?
Yes, sir. Yeah, no,
Good. I'm not asking for much. I just want my community safe. That's all. I'll have you sign a receipt with Victoria. You'll get with Fatima for your bond conditions, and then you guys are free to go.
thank you,
All
sir.
Thank you, Judge.
And this one goes to the heart of what it means to take responsibility. Today, we watched a man stand before a judge with a 2-year-old case, 2 missed court appearances, and 2 forfeited bonds. His lawyer said he couldn't run anymore because the open warrant was blocking his CDL. The judge said, "Pull me once, shame on you." But then, the man told a story. He parked a semi-truck at a tow yard, got on a Greyhound bus, walked 3 city blocks to find the right building, and turned himself in voluntarily. He could have left at any time. So here is the question. The bail system is built on trust, the promise that a defendant will return. When someone forfeits that trust twice, most judges close the door. But when that same person shows up voluntarily, without being captured, without a warrant being served, does that act of voluntary surrender change the moral calculus? Does choosing to return earn back the second chance the Constitution says you deserve? The judge gave him a PR bond today, not because he had to, because a man got on a bus and came back.